Senate roll call, Day 10, Tuesday, January 23rd. Anderson? Baldwin? Barlow? Beitman? Boner? Bouchard? Brennan? Case? Cooper? Dockstetter? Ellis? French? Murphy? Guru? Hicks? Hutchings? Jones? Excuse me, Ide? Jones? Kinski? Kolb? Landon? Larson? McEwen? Nethercott? Pappas? Excused. Rothfuss? Salazar? Schuler? Scott? Steinmetz? President Driscoll?
Here.
30 present, 1 excused.
Okay, first action, we'll roll the clocks back an hour, so we're on time this morning. So apologize to everybody that we're late. I don't think we can roll them back unless we can stop them. So I'm going to start, and our minister will follow. But first thing we're going to do, he's going to lead us in a prayer on, we lost 5 students on I-80 in an exceptionally tragic accident that were going from Jackson Hole Bible College home. Solomon Carrera, Magdalene Franco, Andrea Prime, Susie Prime, and Ava Luplo. They attended the Faith Bible Fellowship in Sullivan Hills High School in Little Rock, Arkansas, and it's absolutely tragic to see these things happen. And he's going to lead us in a moment of prayer, and then he'll go on into it. Our pastor today is Reverend Rick Veit of St. Mark's Episcopal Church. So please join us in prayer.
I offer us a prayer or a collect for quiet confidence. Let us pray. O God of peace, you have taught us that in returning and rest, we shall be saved. In quietness and in confidence shall be our strength. By the might of thy Spirit, lift us, we pray thee, to thy presence, and lift those 5 students and their families to thy presence, where we may be still and know that thou art God. For it's in your holy name that we pray. Amen.
Senator Rothfuss, would you lead us in the pledge? I was trying to say your title, but I'm having a hard time with it.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Mr. Minority Floor Leader. Now I remember your title. It took me a bit, though. Reading, correction, approval of the journal. Will the reading clerk please read the journal committee report?
Mr. President, your journal committee reports that the Journal of January 20, 2023 has been read and recommends it to be approved. Senator Larson, Chairman.
Any objections? There being none, the report is approved. Doctor for the day, once again, no doctor today. Today in Wyoming history. On this day in 1933, 3 Wyoming women were invited to visit the graves of American soldiers in France. Quote of the day: progress is impossible without change, and those who cannot change their minds cannot change anything. George Bernard Shaw. Rules adopted last week have now been published. Final date for bills, noon today. If you don't have them, I'd suggest you jump up and go get them signed off and turned in. Final days to be introduced is 5 p.m. on Thursday, 2023, so we'll have a bunch read in. We've got a special guest this morning, very special guest. He's committed his life to keeping others safe. Mr. Bill Law has served as Torrington firefighter for the last, catch this, 60 years, acting as the president and assistant fire chief. He is trained in fire suppression, water rescue and recovery, farm and auto accident recovery, and is a certified EMT and wildland fire practice. Fellow senators, please help me welcome Mr. Bill Law to the Senate.
Privilege of the floor, Mr. President. You can't hear me, I know.
You have privilege to the floor. That is a young 60, Mr. Law.
Yeah, that's- And I'm taller than he is. Fellow senators, it's my pleasure to introduce Mr. Bill Law. If you can somehow imagine 60 years on the fire department, I know Senator Beitman could imagine a few of those, maybe not 60. But imagine being, and I said in the last gallery, I talked about, leaving your favorite food behind, leaving your warm bed behind to go out on a cold day like today, leaving whatever your favorite thing is you're doing. At some point, guaranteed in 60 years, I guarantee Bill has left a lot of good food on the table, maybe a cart full of groceries at the grocery store. We've all been there and done that. As I joked on the other floor, that's why I started eating frozen burritos. I didn't care if I left those behind. I would direct your attention also today up in the gallery, standing up here, we have a number of firemen who've come to participate in this, and I think they all deserve a round of applause as well, if you could please welcome them.
Here.
I think we should ask for a show of hands, how many of you eat frozen burritos? Just me? Okay, without further ado, I've got a whole biography here. It makes me tired just to look at it. Mr. Law is a very active, and he's still active. He's still the fire warden in Goshen County. So he's still out there and still doing it. I've been doing it for 60 years plus. And so with that, no further ado, I welcome Mr. Law.
Thank you, Senator Baldwin. And what a humbling experience to be here before the senators of the state of Wyoming. We talk about my service. I applaud you for your service to the residents and the citizens of Wyoming and our nation, so thank you. And for my comrades up above, thank you for caring enough to come. This 60 years, it does go fast. I look at the way they put the uniform together. The first 40 seemed to drag. I got to tell you, the last 20 go in a hurry. But it is still something that, we do not do on our own. It's a pleasure to work with all of those that were there before me, who helped set the path for me to follow and helped me along the line. So we continue to be a part of the service to Wyoming, and it's always an honor to be included as a firefighter. Think about this. What child doesn't want to ride on a fire truck? I've been getting to do it for 60 years. It just doesn't get a lot better than that. So thank you for this experience. It's my pleasure. But I offer right back to you my congratulations, and to my Senator Sherry, thank you for your support. And you gentlemen and ladies, thank you. And that's about it. Nobody wants to listen to me. My wife, I think I'm losing my voice. I don't know if she giggles or celebrates, but it's happening. So thank you so much.
We do love our firefighters and our first responders. So, and what adult does not want to ride on a fire truck as well. It's not just for kids. So, messages from the House.
From the House of Representatives, message number 127, January 20, 2023. Mr. President, the following bills passed the House on third reading and amended form by the votes indicated. House Bill number 7, Underage Marriage Amendments, ayes 36, noes 25, excused 1. Message number 128, January 20, 2023. House Bill number 41, Lightweight Trailers Permanent Registration, ayes 61, excused 1. Message number 129, January 20, 2023. House Bill number 73, Annexation Vote Requirement, ayes 39, noes 2, excused 1. Message number 124, January 20, 2023. House Bill number 33, School Finance Career Technical Education Grants, ayes 37, noes 24, excused 1. Signed, Katie Talbot, House Chief Clerk.
Thank you, Randy. Senator Grew,
Privilege of the floor, Mr. President.
granted.
This morning, ladies and gentlemen of the 67th, we have with us a group from the Equality State Policy Center. They are here to learn the legislative process. They are the SHAPE class of 2023, and they hail from Natrona, Albany, Teton, Crook, Laramie, Carbon, and Fremont counties, and they're standing right there. Give them a big Senate welcome.
Second reading. Yeah, I'll have that after lunch. What's that? Reports from standing committees.
January 24, 2023. Mr. President, Committee Number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred Senate File 33, Defining Aircraft for Purposes of Hunting Prohibitions, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Baldwin, Ellis, Guru, Jones, and Schuler. Senator Schuler, Chairman. January 20, 2023, Mr. President, Committee Number 4, Education, to whom was referred Senate File 117, Parental Rights in Education, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Beitman, Brennan, Scott, and Steinmetz. No, Senator Rothfuss. Senator Scott, Chairman. January 24, 2023, Mr. President, Committee Number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom was referred Senate File 113, Architects Practice Act Amendments, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Baldwin, Ellis, Guru, Jones, and Schuler. Senator Schuler, Chairman. January 20, 2023, Mr. President, Committee Number 8, Transportation, Highways, and Military Affairs, to whom was referred Senate File 17, Off-Road Recreational Vehicles, Safety, and Insurance, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Boner, Brennan, Furphy, Kolb, and Pappas. Senator Boner, Chairman.
Thank you. Bills on second reading. Senate File 23, second reading of the Senate file.
Senate File 23, Treatment Courts Transfer to Judicial Branch.
Senator Hutchins.
Thank you, Mr. Chairman. I'd like to just open up the debate on this bill. I have cause for pause on it. And one of the things I mentioned last week was Article 5, Section 16 of our Wyoming Constitution, which states Supreme Court judges limited to judicial duties. No duties shall be imposed by law upon the Supreme Court or any of the judges thereof, except such as are judicial, nor shall any of the judges thereof exercise any power of appointment except as herein provided. I also mentioned Article 2, Section 1 of our Wyoming Constitution, which speaks on separation of powers. This bill, in my view, and a view of one of our constituents, crosses the lines with judicial and executive branch duties. And I believe that once we cross those lines, Mr. President. I don't know if we'll ever be able to cross back. Did you want to say something? Okay, I'm sorry, your expression. A court supervises treatment, a treatment program has the obvious judicial component of the courts ordering mandated probationary actions upon citizens to help them. However, authorizing responsibilities and oversight to the Wyoming Supreme Court over the actual medical treatment in these programs to address mental health needs to those same citizens is concerning to me. The court supervised treatment programs that we see within this bill and treating the addictive behaviors, treating mental health, social services, and child protection services, those all belong under the Wyoming Department of Health. And again, the blurring of the lines is of concern to me. The judicial branch also requests having the responsibility and oversight of treatment programs for juveniles. The juveniles/juvenile courts occur in the bill 10 times. The word parents or guardians occurs 7 times, and child custody is referred to 3 times. The best interest of the child is mentioned only once, which is of concern to me. The Wyoming Constitution also says in Article 5, Section 29, at the last sentence, that such courts shall have jurisdiction as the legislature may by law provide. But given these duties, again, mental health issues over to our court system is of concern. Judicial oversight of a juvenile breaking the law by abusing alcohol or drugs is one thing. However, directly inserting the courts as a medical intervener and educator via a treatment program is not only a clear violation of the separation of government branches, it's also a constitutional violating regarding healthcare choices having been made by the parents or guardian in our Article 1, Section 38, Section A of our Constitution. These are some of the things I have concerns with, and if someone could speak on these to ease my mind or not, I would appreciate it, Mr. Chairman. Thank you.
Thank you, Senator Hutchins. Senator Rothfuss. Oop. Senator Landon. One of the two of you.
Well, Mr. President, thank you. I apologize. I didn't follow all of that. I didn't get everything written down or even some of it. But I understand. I mean, there's no question this is a policy decision for the state Senate. I can only attest to you what we ran into in committee. My understanding is that was the same tenor throughout the previous interim. But in committee, we had a Department of Health, which represents our executive branch, and we had a judicial branch of government in the room all at the same time, and all feel very strongly that this gives us an opportunity with these treatment courts to go above and beyond where we have been. I'm pretty confident, Mr. President, in the fact that all of the services that were mentioned by my good friend from Laramie County are still going to be provided by the Department of Health. The administration of the program will move over to the judiciary branch. A piece of that I like, Mr. President, is the fact that moving it to the judicial branch, when it is our judges, our circuit court judges who are serving as these treatment court judges, I think that stands to benefit our state. I hope that helps a little bit, Mr. President. Thank you.
Thank you. Further comments? Senator Scott.
Mr. Chairman, answering the specific questions, I think you do have a classic judicial function here. Essentially, what the judges are doing with regard to the individuals that are involved is supervising a probation and parole, where the question is, If they don't follow the treatment plan, they get revoked, they go back to prison. And that is a traditional judicial function, and appropriately so. So I don't think that it sounds like they're really getting into the executive branch business, but when you look at what they're actually doing, I think it is appropriate for judicial to do, and frankly, it does work pretty well.
Senator Rothfuss.
Thank you, Mr. President. And honestly, I'm not entirely sure which is the better place to put it, executive branch where it's at right now or under the Supreme Court and the judicial branch. But addressing the constitutionality that was raised, which I think is an important question, Mr. President, from my perspective, it seems that it is more appropriate within the judicial branch and reporting to the Supreme Court, as is consistent with really most of the courts in the state of Wyoming, reporting up to the Supreme Court. This is a type of court, and it is serving in a judicial capacity, even right now in the status quo. The fact that it exists under the executive branch is probably more constitutionally disconcerting to me than moving it from where it's at now to the judicial branch, which seems like a natural home. Now, that said, there certainly is a little bit of crossover, and it's semi-enforcement, it's semi-judicial right now. I understand why it is where it is right now, and I believe if it were moved over to the courts, it would still be with the support and cooperation of the agencies that currently work to help support and administer it. These are obviously very important mechanisms in our system, largely our judicial system, to ensure that people are being treated fairly and have an opportunity for rehabilitation. So I'm always supportive of the treatment courts. But I appreciate the concerns about the constitutionality of executive branch separation from the judicial branch. On that point, though, Mr. President, I think this is a better, more constitutional approach than what we have right now, which, all else being equal, is why I'll probably support it, because I believe it belongs with the judicial branch based on its function more than it belongs with the executive branch. It is a little bit grading your own homework when it stays in the executive branch, and that's a cause of concern.
Further comments? Senator
I just
Hutchins,
wanted
your
to say
second
thank
time.
you, Mr. Chairman. Thank you.
Senate File 23, having been heard two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 28, second reading of the Senate file.
Senate File 28, Livestock Infectious Disease Control Tribal Inclusion.
There is an amendment. Could we have the amendment read in?
Senate File 28, second reading amendment number 1, page 2, line 15, delete.
Senator Ellis.
Thank you, Mr. President. I move second reading amendment number 1 to Senate File 28 and ask the body to vote aye. Mr. President, this would make a clarifying amendment on page 2, line 15 and 16, deleting the word both tribes or that's a conforming amendment with our statutory, how we describe the tribes if they can apply for this individually or jointly. The second part of the amendment clarifies that any testing, containment, or reimbursement services provided under our brucellosis statutes do not apply to bison that has been designated as wildlife. This is the current practice and how the program operates, but the committee felt that it was important to make this clarification. And so I think it doesn't hurt the bill, it just makes it more clear, so I'd ask you to vote aye.
Further comments? Thank you. We're on second reading amendment number 1 to Senate File 28. All in favor say aye. Aye. Those opposed, no. Second amendment number 1 to Senate File 28 has passed the Senate. Senate File 28 having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 41, second reading of the Senate file.
Senate File 41, skill-based amusement games authorized locations.
Senate File 41 having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 65, second reading of the Senate file.
Senate File 65, compensation of local registrars, repeal.
Senate File 65, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 76, second reading of the Senate file.
Senate File 76, Wyoming Digital Asset Registration Act.
There is an amendment. Could I have the amendment read in, please?
Senate File 76, second reading amendment number 1, page 11, line 8, delete.
Senator Rothfuss.
Mr. President, in the interest of time, I just asked that this be laid back an additional day. I have another amendment being prepared, so let's do this one tomorrow.
With no objection, it is so ordered.
Thank you.
Senate File 87, second reading of the Senate file.
Senate File 87, natural resource funding, large project threshold increase.
Senate File 87, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 96, second reading of the Senate file.
Senate File 96, omnibus water bill, planning and administration.
Senate File 96, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 100, second reading of the Senate file.
Senate File 100, designation of spouses, revocation upon divorce or annulment.
There is an amendment. Could we have the amendment read in, please?
Senate File 100, second reading amendment number 1, page 2, line 16, delete.
Senator Barlow.
Thank you, Mr. President. Members, I move Senate File 100, second reading amendment number 1. Ask for your favorable consideration. Members, what you'll see on the first 8 lines of this is really some conforming language consistency throughout the rest of the bill. Instrument for document, and that's the extent of that. And that, like I said, that's conforming this part of the bill with the remainder of the bill. The third thing is more substantive. This is why I asked for this bill to be laid back twice. And what it comes from is those folks that are actually responsible for paying some of those benefits, saying that, at what level of liability do they have if they make a distribution, a payment, or exercise something based on one of these instruments now, that in good faith, they did not know there was a divorce, annulment, or remarriage. And so what this basically says is, no harm, no foul. You didn't know, you're not responsible, you're not held liable for making that distribution. So this was the shortest version we could come up with. It may not be perfect, and as this bill goes through the process, there may be some additions to it, but the first version they gave us was about 1,000 words. So I went with the short version, Mr. President. I hope you find it acceptable to the Senate. Thank you.
Further comments? Senator Hutchins.
Thank you, Mr. Chair. Lines 12 through 22 of the amendment, this bill in and of itself really bothers me. And to think now we're saying that if someone, and if I have it wrong, the bringer of the amendment can explain it to me. We have a case where there's been a marriage, a divorce, and the spouse has not transferred any benefits onto the new spouse, and someone, insurance company, whatever, pays the old spouse. We're saying you're not going to be responsible for having done that. Can you explain to me why we're even in this process of saying that? I don't know, this whole amendment bothers me in that I'm not understanding how we can tell a company that's paid over to an ex-spouse something that the prior spouse meant for them to have and didn't change their policy. How are we doing this? If you can explain that to me. Thank you, Mr. Chair.
Good question. Senator Rothfuss.
Thank you. I'll try and address that to give the bringer an opportunity to clean up afterwards if there's more questions. I think this amendment specifically addresses the good senator from Laramie County's concerns about how challenging it would be without the language to predict circumstances or to have a third party somehow be obligated to investigate, well, are they still married? Should we make this transaction? And in making that transaction, then they might be moving against what, according to statute, should be a terminated marriage and should be recognized through that termination. This just takes the risk away from that third party where they will continue to act as they do now in good faith, make good faith attempts to facilitate transactions based on the evidence they have, which is a continuation of a marriage because nobody's told them otherwise, and then carry that forward. So when the senator talks about how will this be done, how could this be done, I think that's the motivation that leads to the bringing of this amendment. How could you possibly know as a third party at all times whether a marriage was still in place? And if you were legally obligated to know that and would be then financially responsible for knowing that, how could you do that? And in the absence of that possibility, which this amendment reflects, you would need to ensure that you had some type of indemnification or hold harmless accordingly. So that's the way that I interpret it, is to address the inability to know.
Thank you. Senator Hutchins?
Mr. Chair, I got that. I got that. What it is my understanding that how do we know as a body here or anybody what a previous spouse intended? What if I wanted my previous or my ex-spouse to have something, and how do we know that they didn't? If they have not changed their policy or plan or whatever, how can we as a body step in and say, well, we're going to assume because you divorced Marilyn and you're now married to Jill, you want everything to go to Jill. Well, what if he really liked Marilyn and he wanted Marilyn to have something in his policy? That's what I'm touching on, how we're getting into the weeds at all. Thank you, Mr. Chairman.
Senator Case?
Thank you, Mr. President. I'm an expert on this topic.
Firsthand.
It's always great when I can bring my expertise to bear to the works in the Senate. I do know it is very common, I think, for people to have a good relationship with their ex-spouse. And they cooperate in raising children, and sometimes it's not all it seems, but what a person can do, if they want to provide for a former spouse, they can provide for a former spouse in the will or the instrument. This is in the case that they haven't done that. And saying that if they haven't done that, we're going to assume that they didn't mean to do that. And that does happen. You have things in banking, Mr. President, called a pay on death account. When you first set that account up, it might have been 20 years ago, you said pay on death goes to this other person. And then all this time passes, you get divorced, you never change that. And, this is that circumstance. That account still says pay on death to this person. And so this gives the financial institution, the ability to have some coverage in that situation. But if I certainly wanted to, I could leave it that way, and I could specify in my will that I do want that to go to my former spouse. So, like I said, I'm an expert on this, Mr. President. I've been through it.
Any further questions? Well done. Question being called. We're on second reading amendment number 1 to Senate File 100. All those in favor say aye. Those opposed, no. The ayes have it. Second reading amendment number 1 to Senate File 100 has passed the Senate. Senate File 100 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 102, second reading of the Senate file.
Senate File 102, Food Freedom Act Amendments.
There is an amendment. Could I have the amendment read in, please?
Senate File 102, second reading amendment number 1, page 2, line 14, strike.
Senator Salazar.
Thank you, Mr. President. I move second reading amendment number 1 to Senate File 102 and ask the body to vote yes. Honorable members, this is simply a technical correction that LSO requested. We're simply changing the line on page 2, line 14 from 1149-103 and inserting 1149-104.
Thank you. Questions? Question being called. We're voting on Senate File 102, second reading amendment number 1. All in favor, say aye. All those opposed, nay. Second reading amendment number 1 to Senate File 102 is passed the Senate. Senate File 102 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 106, second reading of the Senate file.
Senate File 106, 2023 large project funding.
Senate File 106 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Bills on third reading and final passage. Mr. Majority Floor Leader, do you have a consent list?
Mr. President, I do have a consent list, and I move third reading consent list, which is as follows. Senate File 35, school.
Thank you, and sorry.
I'll start over. Mr. President, we do have a consent list. I move third reading consent list, which is as follows. Senate File 35, school crosswalks and pedestrian crossings appropriation. Senate File 38, special license plates, Oregon donation. Senate File 40, Federal Political Action Committee reports. Senate File 53, Wyoming National Guard medical insurance premiums. Senate File 67, multi-purpose vehicles, disabled license plates. Senate File 68, prescriptive easements for water conveyances. Senate File 86, voter identification, concealed carry permit. Senate File 94, Federal Indian Child Welfare Act codification. Senate File 18, fund balance calculations, federal encumbrances excluded. Senate File 122, non-resident workers, vehicle registration extension. Senate File 123, military dependents, school choice. And Senate Joint Resolution 6, political expenditures.
Thank you, Mr. Majority Floor Leader. You did Senate File 18 as 118 as 18. Could you restate Senate File 118, please?
Mr. President, Senate File 118, fund balance calculations, federal encumbrances excluded.
Thank you. Would anybody like any of these bills removed from the consent list? Senator Ellis.
Thank you, Mr. President. I'd ask that Senate File 94 be removed from the consent list.
Without objection, Senate File 94 has been removed from the consent list. Senator Beitman.
Mr. President, I ask Senate File 40 be removed from the consent list.
Without objection, is so ordered. Senate File 40 has been removed from the consent list. Having been read 3 separate times, the question is, shall these bills pass the Senate? Senate File 35, school crosswalks and pedestrian crossings appropriations. Senate File 38, special license plates, organ donations. Senate File 53, Wyoming National Guard medical insurance premiums. Senate File 67, multipurpose vehicles, disabled license plates. Senate File 68, prescriptive easement for water conveyances. Senate File 86, voter identification, concealed carry permit. Senate File 118, farm balance calculations, federal encumbrances included. Senate File 122, non-resident workers, vehicle registration extension. Senate File 123, military dependents, school choice. Senate Journal 6, political expenditures. The clerk will call the roll.
On the consent list, Anderson. Baldwin. Barlow. Beitman. Boner. Bouchard. Brennan. Case. Cooper. Dockstetter? Ellis? French? Murphy? Guru? Hicks? Hutchings? Ide? Jones? Kinsky? Kolb? Landon? Larson? McEwen? Nethercott? Pappas?
Excused.
Rothfuss? Salazar? Schuler? Scott? Steinmetz? President Driscoll.
Aye.
On the consent list, 30 aye, 1 excused. Senate File 35, are there any changes? Beitman? Beitman, aye to no. Hicks? Aye to no. Hutchings? Aye to no. Ide? Aye to no. Steinmetz? Aye to no. McEwen? Aye to no. Salazar? Aye to no. Bouchard? Aye to no. French? Aye to no. Larson? Aye to no. Closing vote. Closing. Vote closed. Senate File 35, 20 aye, 10 no, 1 excused. Senate File 38, are there any changes? Larson? No. Beitman? No. Salazar? No. Ide? No. Bouchard? No. Hicks? No. McEwen? No. Steinmetz? No. Kolb, aye to no. French? Aye to no. Closing vote. Closing. Vote closed. Senate File 38, 20 aye, 10 no, 1 excused. Senate File 53, are there any changes? Closing vote. Closing. Vote closed. Senate File 53, 30 aye, 1 excused. Senate File 67, are there any changes? Closing vote. Larson? No. Aye to no. Closing vote. Closing. Vote closed. Senate File 67, 29 aye, 1 no, 1 excused. Senate File 68, are there any changes? Case, aye to no. Rothfuss, aye to no. Ellis, aye to no. Bouchard, aye to no. Closing vote. Closing. Vote closed. Senate File 68, 26 aye, 4 no, 1 excused. Senate File 86, are there any changes? Closing vote. Closing. Vote closed. Senate File 86, 30 aye, 1 excused. Senate File 118, are there any changes? Closing vote. Closing. Vote closed. Senate File 118, 30 aye, 1 excused. Senate File 122, are there any changes? Closing vote. Closing. Vote closed. Senate File 122, 30 aye, 1 excused. Senate File 123, are there any changes? Case, aye to no. Rothfuss, aye to no. Steinmetz, aye to no. Ide, aye to no. Closing vote. Closing vote closed. Senate File 123, 26 aye, 4 no, 1 excused. Senate Joint Resolution Number 6, are there any changes? Beitman? Aye to no. Salazar? No. Aye to no. Kinski? Aye to no. Aye to no. Ide? Aye to no. Aye to no. Hicks? Aye to no. Aye to no. Kolb? Aye to no. McEwen? Aye to no. Jones? Aye to no. Hutchings? Aye to no. Steinmetz? Aye to no. French? Aye to no. Cooper? Aye to no. Brennan? Aye to no. Larson? Aye to no. Dockstetter? Aye to no. Boner? Aye to no. Bouchard? Aye to no. No. Baldwin. Closing vote. Closing vote closed. Senate Joint Resolution 6, 12 aye, 18 no, and 1 excused.
Having received the affirmative vote of the majority of members elected to the Senate, Senate File 35, School Crosswalks and Pedestrian Crossings Appropriations, Senate File 38, Special License Plates, Organ Donations, Senate File 53, Wyoming National Guard Medical Insurance Premiums, Senate File 67, Multipurpose Vehicles, Disabled License Plates, Senate File 68, Prescriptive Easement for Water Conveyances, Senate File 86, Voter Identification Concealed Carry Permit, Senate File 118, Fund Balance Calculations, Federal Encumbrances Excluded, Senate File 122, Non-Resident Workers Vehicle Registration Extension, and Senate File 123, Military Dependents School Choice, have passed the Senate. Senate Journal 6, having failed to receive the affirmative vote of the majority of members elected to the Senate, Senate Journal 6 has failed to pass the Senate. Senator Rothfuss.
Senate Joint Resolution 6 rather than Senate Journal 6, so if you want to
Excuse me, I'll
restate that
start
Senate
over.
Joint Resolution. Thank you.
Thank you. That is my bad. Senate Joint Resolution 6, having failed to receive the affirmative vote of the majority of members elected to the Senate, Senate Joint Resolution 6 has failed to pass the Senate. Thank you for the correction. Senate File 40. Excuse me. Senator Larson.
Mr. President, I don't know if this is the correct time to do this, but I'd like to reconsider Senate Joint Resolution Number 6. Make a motion to do that?
Is that in order? That is in order. So Senate Joint Resolution 6. The first vote we have will be the vote for reconsideration, whether to reconsider. The second vote will be a vote on the bill again. Chief Clerk will call the roll for reconsideration. Senator Larson, the motion should be having voted on the prevailing side, if you have a script. Excuse me,
Mr. President, voting on the.
having voted.
Mr. President, having voted on the prevailing side, I make a motion to
On Senate joint resolution.
on Senate Joint Resolution 6, I make a motion for reconsideration.
Thank you. Chief Clerk will call the roll.
For reconsideration of Senate Joint Resolution Number 6, Anderson? No. Baldwin? No. Barlow? Aye. Beitman? Aye. Boner? No. Bouchard? Aye. Brennan? No. Case? Aye. Cooper? No. Dockstetter? No. Ellis? No. French? Aye. Murphy? No. Guru? Aye. Hicks? No. Hutchings? No. Ide? Aye. Jones? No. Kinski? No. Cole? No. Landon? No. Larson? No. McEwen? No. Nethercott? Aye. Pappas excused? Pappas?
Excused. Senator Pappas, you actually have to vote. You're in the chamber. Excuse me. I didn't. Aye.
Pappas? Aye. Rothfuss? Aye. Salazar? Aye. Schuler? Sorry, Schuler? Aye. Scott? No. Steinmetz? No. President Driscoll?
No.
No. Beitman, aye to no. Closing vote. French, aye to no. Ide, aye to no. Closing vote. Closing. Vote closed. Motion for a reconsideration. 9 aye, 22 no.
Reconsideration vote has failed. We will not move on to vote. Senate Journal 6 is done. Third reading, bills on third reading, Senate File 13.
Senate File 13, Bar and Grill Liquor License Amendments, sponsored by the Corporations Committee, an act relating to alcoholic beverages.
The bill has an amendment because we have it read in.
Senate File 13, third reading amendment number 1, page 8 after line 12, insert.
Senator Ellis.
Thank you, Mr. President. I move third reading amendment number 1 to Senate File 13 and would ask this body to vote aye. On second reading, you'll recall that there were some definitions added through an amendment on first reading to amend some requirements for issuance of new bar and grill licenses. As you know, these new licenses would be based on population and other formulas, but there were also additional provisions required, and one specifically had it related to entertainment. And this would have authorized that these new bar and grill licenses be served to or provided to establishments that provide entertainment, which include amusement regardless of age restrictions, but that it also had some language about whether or not they would apply to certain machines that are regulated under the Wyoming Gaming Commission. On second reading, we passed an amendment that would have clarified that did not include historic horse racing machines. At the time, I explained my concern that in my community, our county commissioners can make those determinations, but we really haven't given them grounds. So in visiting casually with my county commissioners, I think there's a concern out there that if they are to deny any requests for these additional HHR machines, they could be taken to court and this be litigated. And so I don't know that when we talk about local control that we've really adequately given our local authorities the ability to say no. So what this amendment would do, Mr. President, would be to clarify that any of these new licenses going forward would be subject to these limitations and these definitions, but that they would not affect previous license holders. Certainly it wasn't my intent to, disrupt any current bar and grill license holders and what they've got going in their establishments. So that's what this third reading amendment would seek to do, and I'd ask the body to vote aye.
Other comments? Question being called. We are on third reading amendment number 1 to Senator Landon, excuse me.
Mr. President, my apologies. I did want to rise and just remind all the senators, we reached a compromise that included, several different parties as this came out of committee. My only heartburn with something like this is that it takes us outside of all of that effort that was made in the hallways and compromises that were made. And, my preference is going to be to try to return this bill to where it is and send it on down the hall. But that's entirely up to each of the senators to make their vote. But this does change the bill fairly dramatically. Thank you.
For or opposed to the amendment, Senator?
I'm against the amendment. Thank you, Mr. President.
Further comments? Senator Barlow.
Thank you, Mr. President. So I do appreciate the good bringer of the amendment and the intent of the amendment, but I'm still not convinced it accomplishes what we're trying to do here. So we have issuance, and then we have annual renewals. And so what I think we're trying to do is draw a line in the sand. If they are existing licenses that would fall under this type of gambling, which is an exception to gambling, actually, they would not be eligible for these new licenses. I understand that. But I still am concerned that when you say issued licenses, this actual bar and grill license issued on or after, issued, is that only applicable to first-time initial licenses, or is issued also a term of art that is to all licenses which are issued annually? Thank you, Mr. President. A question. Thank you.
Further comments? Further comments? Senator Ellis, your second time.
Thank you, Mr. President. I want to express my appreciation to the Corporations Committee for their work in bringing this bill. As it came out of committee, I read the bill, had some questions about it, but it has been substantially amended throughout this process. The first reading amendment we adopted includes some new definitions in an effort to try and combine this bill with another bill. And so, I can appreciate the compromises that were made, but I certainly wasn't invited to those conversations. And that's our job in this floor, is to bring forth concerns by our constituencies. Living in Cheyenne, senators, I can tell you that the number of HHR machines has doubled in Wyoming over the past 4 years. There used to be about 1,000 in 2020. There are now 2,200. And so my concern is with the growth and expansion of this through these additional bar and grill licenses. I want to be very clear that I support the intent of this. I think communities like mine want to have venues where families can come together to have some games, but I just really am concerned about flooding the market, quite honestly, Mr. President. So to answer the speaker from Campbell County's concern and question about the effective date, I expressed that concern clearly in my instructions to LSO, that this is to be clearly only, that these provisions and these changes only apply to prospective licenses issued, authorized under this act. So if we didn't thread that needle, I had included the good senator in some of those emails, and this was the language that our LSO produced. Along those lines, I think our intention is clear. There is new language in here about 60% of the revenue coming has to be from food services and not through the sale of alcohol. So, if we don't have that prospective language, then are all bar and grill license owners currently operating subjected to these new requirements? So this bill does have broad implications, but I think that this amendment achieves what we're getting after. I'd urge your aye vote, and I think we don't want to disrupt current bar and grill liquor license holders from their current practices. And so that, this amendment, I believe, clarifies that.
Question being called. We're on third reading amendment number 1 to Senate File 13. All in favor, say aye. Those opposed, no. Division being called. All in favor, please stand. Those opposed, please stand. Thank you. 13 in favor, 18 opposed. Third reading amendment number 1 to Senate File 13 has failed. We have another amendment. Would the reading clerk please read the amendment?
Senate File 13, third reading amendment number 2, delete.
Senator Landon.
Mr. President, thank you. I would move third reading amendment number 2 to Senate File 13. Fellow senators, I don't know if this has ever happened to you, but over the weekend we took off, headed north to get out of town for a little bit. And all the way home, I started thinking about this bill. I bet it's never happened to any of you. No. So I just kept wallowing it in my head, Mr. President, all weekend. And what I kept coming back to in my head was, we believe in local control. Some of us even campaigned on it. We believe in local control, except when we don't. And so this amendment attempts to go in and just rectify what I think we did on Friday that is causing me some heartburn. What we did on Friday, fellow senators, was to adopt an amendment on second reading, which basically told the local licensing authority what they can and cannot consider with regard to horse racing machines. It didn't say anything about skill-based amusement games. It only singled out one set of these gambling type games. And albeit, I even commented on the floor on Friday, I'm beginning to get concerned about how many of these sorts of devices we have out across the state. That's for conversation a different day. What this conversation is about is how this bill came out of committee. We worked pretty hard. I visited early this morning with the bringer of the compromise amendment that we adopted on first reading, and we both felt fairly strongly. I can't speak for the good senator, but I would say it was kind of important in committee that we allow these local licensing authorities to do their job. They know these communities better than we do, Mr. President. I think this is the right amendment to pass because it gets the bill back to its original form, which says the local licensing authority can take into account anything they need to take into account. Now, we also go back into paragraph J with this amendment, and my attempt was to get to what the good senator from Laramie County, I think, was referring to on Friday, which is they can take into consideration the type. The licensing authority shall consider the type of entertainment. I think that drills us down a little deeper and helps those licensing authorities to know that, yes, they can make those sorts of determinations. I want to give this authority back to the local licensing authority, Mr. President. That's what this amendment does. I hope you'll support it. Thank you.
Other questions? Senator Ellis.
Thank you, Mr. President. On and against the amendment. Senators, if you look at the language that we adopted, it says entertainment shall not include adult entertainment. We've already invaded on local control right there. We said no entertainment as defined by the local licensing authority. But we said we know it, we'll know it when we see it. Then it says or gambling, but there are exceptions to gambling. When I visited with my county commissioners last week, I asked about this very issue. And I asked, can you deny an applicant who wants more of these machines? And the answer was, we're nervous to. What grounds do we have? We don't like them? We can't say that. Why did we approve those applications, but why do we deny these? In our statutes, we really haven't fleshed out what grounds our county commissioners have for being able to say no. So when they issue these, it's under the premise of, well, I said yes to these guys, I can't say no to these. And so we've got a situation where there is no end to this. And so unless and until we start figuring out how that should work and actually giving our counties the tools to be able to say no, to cap it at a certain amount, then they're left in this horrible predicament of saying, well, if we say no, we're probably going to be sued. And if I represented one of these companies, I'd probably say, yes, let's do it. So even the language that we have adopted says you shall consider it. What does that mean? When a court says that, they say, well, yeah, we got this information, we considered it. Doesn't mean it says they can say no based on it. And that's how these court cases go. So that's why I think we need to be very clear in our discussion of these additional bar and grill licenses that right now we're just trying to put the brakes on it. If we want to look at the entire industry, come up with some solutions, really empower our county commissioners with tools to have grounds to say no, then I'm all for removing that language, and that can be done in a subsequent look at this bill. But right now, looking at my community, when I talk to people who operate businesses, that is one concern I've heard over and over again, is what's going on with all of these casinos popping up in Cheyenne. So that's why I brought the amendment, Mr. Chairman. I think we do need to start getting our arms around it. And this is a pause on that. If we, look at the structure in the future, we can revisit this language, but that's the intent of this amendment. So I'd urge the body to reject this amendment.
They're cold.
Thank you, Mr. President. Well, I'd like to share a story that happened to me as a county commissioner. And it revolves around this same subject. That legislative body clearly gave us an authority to put a limit on, in this case, it was historical horse racing, live horse racing. And this supposed ability was overturned by the state Supreme Court and said that that we were incorrect, or excuse me, by a district judge. It stands as the only time I signed under protest as a commissioner. And I talked to the legislative body about it, one of the people that orchestrated that bill, and they said, well, they shouldn't have done that, but they did. So this is an issue about local control on one hand, but we need legislative oversight on the other hand in order to make this work. And without both of them together, I'm afraid it's not going to work well. So I stand against this amendment. Thank you, Mr. President.
Further explanation. Senator Barlow.
Thank you, Mr. President. So without the amendment, there is no limitation. There is no limitation. So if you want any semblance of giving local control, this amendment is that. It's only one word added to the statute, and that is the type of entertainment or food sales. And I'll take this a step backwards. Let's quit it, but I'm not going to focus on the entertainment. Let's talk about the food sales. Food sales, we've traditionally talked about, and under the current statute it's basically you have to have your own food license. It's in-house. But what if some of these folks don't have the space, and we heard this in testimony in the committee, they don't have the space for a kitchen, a commercial kitchen in their building. They're going to actually, contract with food trucks to be just outside so they can have that food coming in out of the door while the entertainment is going on and while the alcohol sales are there, because that's an important part. As we heard in testimony during the committee, alcohol sales, food sales, that go hand in hand. Add entertainment into that, well, you start running into space restrictions. So you got to give local licensees, the businesses that are doing business in our community, the options, as many options as we can. And if this is not the perfect language to give local control or local ability to have a say, then the process continues. But I think if we don't add something, it doesn't change the bill. This one amendment is not going to change the intent of the bill, that there is no control on exceptions to gambling without this amendment or with the bill with the amendment. Thank you, Mr. Chairman.
Further comments? Senator Rothfuss.
Thank you, Mr. President. I'm for the amendment for largely the reasons we heard about the fact that this, as I read it, certainly, and going back and reinserting the text into the Senate Standing Committee, reading it in, appears to be the most local control, the most flexibility for the local community to make decisions based on their local interests, which they know the best. Again, perhaps it isn't perfect. This is certainly moving in the right direction that I would like to see to give that local control, and as well as to provide an opportunity to stop activities from moving forward, to allow the local community, if they see a type of business that they would not want to award one of these licenses to understand that they have the authority to restrict it. Greater than the previous language, I think this is a real improvement on the bill, and certainly gives me confidence in moving it forward. Thank you, Mr. President.
Your comment, Senator Landon.
Mr. President, thank you for the debate on this second amendment on third reading. I really appreciate the efforts of the senator, and apologize that we didn't get a chance to really visit about this till this morning, but I do think this is important, and I do think the language goes to what my friend from Sweetwater County pointed out, which is it gives a little bit of purview to our localities to say, you know, we can consider what type of entertainment we're talking about here. It says so right in the statute if we pass this. If we don't, I don't think the bill is as good. I like the fact that this amendment gives that control back to the local licensing authority. I hope you'll support it. Thank you.
Thank you. Question being called. We're on third reading amendment number 2 to Senate File 13. All in favor say aye. Aye. Those opposed, no. Motion is passed. Third reading amendment number 2 to Senate File 13 has passed the Senate. Senate File 13, clerk will call the roll. Before I do this. Having been read 3 separate times, the question is, shall this bill pass the Senate? Senate File 13, bar and grill liquor license amendments, pass the Senate. Chief Clerk will call the roll.
Anderson? Aye. Baldwin? Aye. Barlow? Aye. Beitman? Aye. Boner? Aye. Bouchard? Aye. Brennan? Aye. Case conflict? Case conflict Cooper? Aye. Dockstetter?
Dockstetter.
Dockstetter?
Aye.
Aye. Ellis? No. French? Aye. Furphy? Aye. Garou? Aye. Hicks? Aye. Hutchings? No. Ide? No. Jones? No. Kinski? Aye. Kolb? No. Landon? Aye. Larson? No. McEwen? Conflict? Nethercott? Aye. Pappas? Aye. Rothfuss? Aye. Salazar? No. Schuler? Aye. Scott? Aye. Steinmetz? No. President Driscoll?
Conflict.
Conflict. Closing vote. Closing. Vote closed. Senate File 13, 20 aye, 8 no, 3 conflict.
Having received the affirmative vote of the majority of the members elected to the Senate, Senate File 13, bar and grill liquor license amendments, has passed the Senate. Senate File 40, third reading of the Senate file.
Senate File 40, Federal Political Action Committee's reports, sponsored by Senator Case, an act relating to campaign practices.
Senator Biden.
Thank you, Mr. President. The reason why I pulled this, I think my committee was off the floor when this was discussed on Committee of the Whole, so I missed the whole debate on it. And just wanted some clarification what this new language would do to 22-25-106G, because as I read the current law, it's pretty straightforward. And this new language to me, muddies it up a little bit. And I just wanted to talk a little bit more about what this actually does, what we're voting on, and the policy considerations, and the background as to why we need this. So thank you, Mr. President.
Is there a case?
My computer just went blank. It really did. Mr. President, this bill relates to some activities from the last election. They relate to a situation where a federal political action committee was formed. And under our law, federal political action committees don't have to file in Wyoming. The thinking is if you're supporting a federal candidate, you file at the federal government. You file your federal reports. The issue with this particular political action committee, and it was in our northeast, kind of central part of the state, was that, thank you, Senator. They filed as a federal political action committee. I assume they were participating in federal elections, but I don't know. They were late in filing their reports to the federal government. But they also made expenditures in state races. So that's where the problem is. We have this 22-25-106 is an exception to filing campaign reports. So what it says, current language is, it's in Part G, candidates for federal office, campaign committees for candidates for federal office, and federal political action committees shall not be required to file contribution and expenditure reports under this section if the candidate or the committee is required to comply with federal election and law reporting requirements. So if you're a federal report, a federal candidate issue, you deal with the feds. The problem is this political action committee hid behind this federal reporting requirement, but participated in Wyoming elections. We heard from the clerk in that county. It's very well documented that this happened. And to make matters worse, they didn't even file timely their federal reports. So we couldn't look at the federal reports and have them be relevant to our state actions. So, and the federal timing doesn't fit our state election cycle like our state reports. So this goes into the exception and makes an exception if, and says that you don't file the report in Wyoming as long as you are making contributions or expenditures only to federal candidates or for federal issues. But if you make any to the state on state issues, you need to file in Wyoming. That's what this bill does, Mr. And just by way of history, we heard about it in the Corporations Committee at the very last committee meeting. And the committee had broad support for it, but we weren't going to have another meeting to actually look at a bill. So I explained I would bring a personal bill. I made an offer to all members of the Corporations Committee that carried over to sign on the bill, and that's where we're at today. Thank you, Mr. President. I hope that clears it up. Thank you, Senator.
Other comments? Question being called. Excuse me. Senator Bouchard, thank you. Sorry about missing you.
Thank you, Mr. President. I can see where we're going with this, but we know there's a big problem here, and I'm concerned that this language doesn't do what it needs to do. There's a rather large PAC, and it resides in the Lincoln state. And that money got funneled in. It was raised under the pretense of a federal PAC, a super PAC, and then it was funneled in. So under even the way it is now, there's money that's coming into elections that is never going to report that individual that gave money to a PAC that raises millions upon millions of dollars. I think 14 million during that cycle is what they raised. And so if this bill here goes into effect, it really doesn't say that that's illegal. And that's where I'm having a little bit of problem with this bill. I mean, I wish we could lay this back and put some real language in there to make sure that we can stop this so it doesn't happen.
Is that a formal motion?
Yeah, I would like to motion that. Without objection, if we could lay it back and maybe make it a little tighter.
Any objection? Senator Case.
Mr. President, I think I would object. And I reserve my second time after other people have asked questions.
Further comments on the bill? Senator Barlow.
Thank you, Mr. President. So I think this bill is kind of the one loophole at a time. I respect that we all have maybe other items that we think could be adjusted, amended, improved, no different than we did with Senate File 13. We still think there's work to be done there, many of us. This bill takes on one particular issue that was, not just I call it a loophole, but you can drive a semi through it. And it was done in my community. Those actions taken by a Wyoming corporation that also filed as a federal PAC with no transparency to the state of Wyoming, to our election laws. I believe if you looked at the pure intent of the statute, without this new language, I think you could read into the legislative intent. I think what we're trying to do here is clarify legislative intent, and I would ask you to think favorably of this bill and favorably about understanding what is occurring in our elections. To the good colleague from Laramie County, I agree. Let's do more work to get at more of these issues. But this is one we can take an action on today, and I think it is an affirmative action is quite appropriate. Thank you, Mr. President.
Point of order, we had a motion to lay back. There was an objection. So.
Yeah, we can continue the debate, and then I'm going to have a.
So there's not a vote on the motion to lay back? We're just
There
back
will
on the
be.
bill?
There will be.
Order.
Senator Rothfuss.
It was a request, and the request was challenged with an objection. So right now, there is no motion. There's nothing associated with it. It's back to debate on the bill with two, everyone gets their first and second time. If there is a further desire to bring a motion, the requester could make a motion, or anyone else in the chamber could make a motion to lay it back for one additional day. So that's in order, but that question is not on the floor right now. Thank you.
That's correct. That's exactly where we're at. Senator Burchard, would you like to?
Thank you, Mr. President. I mean, I would like to say that I'm not trying to gut this bill or do anything. I want to make it better. I don't think it needs much work. I think it needs just one little piece in it. And I think we could pass a really good piece of legislation here. So I would like to motion to lay it back and vote on it.
Senator Case.
President, I think we can have debate on the motion.
We can.
Okay, so I'd like to address the motion. I don't think that you can make an amendment to this bill in the bill title that will fit what the good senator says. I think we could lay it back for a day, but it's not going to do it. I think the question there is about out-of-state independent expenditures in Wyoming, not under the direction of any candidate or, and so those entities don't have to report in Wyoming. So you need a bill to make them report. And that would be directly in conflict, I think, with the Citizens United case. And I think that would also, that's why we had the earlier resolution, Senate Joint Resolution 6. What that was trying to get at. We just killed it. So how you would amend this bill to conform with something we just killed escapes me, Mr. President.
Further comments? Senator Burchard, would you like to sustain your motion or remove?
Thank you, Mr. President. I would like to address the part about Citizens United. That has to do with nonprofits. This is about PACs more so. That's what we're talking about. As far as the language of what we do to this bill, it would still require reporting. That would be what the amendment would do. I just think it could be stronger. We've got a bill in play here, and there's a way to fix the problem. And I think we should stick to that and do the work of the Senate, make sure we get a good bill.
So you want it to come to a vote? Okay. With that, we're going to do a voice vote on a motion to lay back for 1 day. If you vote aye, the bill will be laid back 1 day. If you vote no, we'll proceed to vote on the bill. All in favor, say aye. Aye. Those opposed, no. No. Motion is passed. We'll go back to the bill that we've failed division. All in favor, please stand. All opposed, please stand. Vote is 14 in favor, 17 opposed. We're back on the bill. Senate File 40 having been read 3 separate times. The question is, shall Senate File 40, Federal Political Action Committee reports pass the Senate? Chief Clerk will call the roll.
Anderson? Aye. Baldwin? Aye. Barlow? Aye. Beitman? No. Boner? Aye. Bouchard? No. Brennan? No. Case? Aye. Cooper? Aye. Dockstetter? Aye. Ellis? Aye. French? No. Murphy? Aye. Guru? Aye. Hicks? Aye. Hutchings? Aye. Ide? No. Jones? No. Kinski? Aye. Kolb? No. Landon? Aye. Larson? No. McEwen? No. Nethercott? Aye. Pappas? Aye. Rothfuss? Aye. Salazar? No. Schuler? Aye. Scott? Aye. Steinmetz? No. President Driscoll?
Aye.
Aye. Closing vote. Hutchings? Hutchings, aye to no. Closing vote. Closing. Vote closed. Senate File 40, 19 aye, 12 no.
Having received the affirmative vote of the majority of the members elected to the Senate, Senate File 40, Federal Political Action Committee's reports, has passed the Senate. Senate File 94, third reading of the Senate file.
Senate File 94, Federal Indian Child Welfare Act codification, sponsored by Senator Ellis, an act relating to domestic relations.
Senator Ellis.
Thank you, Mr. President. There are no amendments to this bill, but I wanted to pull it off the consent list in response to some questions and emails I'd received this morning. This is a big bill, so just to kind of back up and get everyone back up to speed on what this bill seeks to do. Right now, there's a federal law called the Indian Child Welfare Act, which has some protocols in place of when the child's, if a child is Indian, whether or not that child is subjected to tribal court and whether or not they're subjected to state court. And that largely depends on whether or not the child is domiciled on the reservation. If that child's domiciled on the reservation, tribes have exclusive jurisdiction through their tribal courts to make determinations about placement for that child if there are shelter care needs or a termination of parental rights proceeding. If the child is off reservation, state courts have some requirements. They have a duty to notify the child's tribe or potential tribe, and those tribes can have a right to intervene in those state court proceedings. The act also provides a preference for placement of children, first providing one to a member of the child's family, then to other members of the child's tribe, other Indian families, and then other Indian placement. This act is being discussed right now in the U.S. Supreme Court, and I want to be clear that this act does not change the status quo. You may have received some emails or correspondence, I certainly was aware of one, where one family talks about how an Indian child has been horribly abused and has concerns about the placement of that child beyond. This act changes nothing. If this act fails, that situation isn't addressed because the federal law is still in place. To be clear, this is a very difficult issue to talk about because we do hear about stories who are treated poorly. Senators, this happens on reservations and off reservations. We hear stories about children who are then placed in foster cares. And I want to say there's wonderful foster families out there, but every now and again, we hear horrible stories about foster families, either on reservation or off reservation. So I just want to be very clear, these can be very sensitive and painful situations because they do involve children and they do involve horrible acts. But to be clear, this act really won't change anything. It would maintain the status quo. We will know more when the Supreme Court issues its opinion. From there, we can make further adjustments if we need to repeal this legislation, adjust this legislation, or address it in any other way. But for now, this is really a safety measure so that we don't change the status quo of what's happening out there until we have a chance to reconvene and discuss how we want to go forward. So I know that there are some stories out there circulating, but I just wanted to make clear and answer any questions. This is a stopgap for us to look at this issue in the future, and I'd urge your aye vote.
Further comments? Senator Rothfuss.
Thank you, Mr. Chairman, and I appreciate the opportunity to debate this and was a little concerned when we had it on Committee of the Whole that it wasn't really debated, Mr. Chairman, and because I don't know enough about these issues and don't know enough about the details. And so only recently had an opportunity to understand that there was any concern, which it's too bad it was kind of this late in the game, so we didn't have the opportunity on Committee of the Whole to fully discuss this. But the question I have, and maybe other proponents could take an opportunity to weigh in, and others with concerns could take an opportunity to weigh in, because I think it would be beneficial to discuss this 31-page bill before moving it along. But Mr. President, the question I have then, if there are some concerns out there, gets back to the nature of why this is being brought, which is that there is apparently a U.S. Supreme Court case which potentially would lead to, or not lead to, depending on how the ruling goes, a ruling that the federal act may be unconstitutional in some capacity. It's my understanding that's equal protection related. I'm not entirely sure whether that's accurate, but that's my understanding. And so the question, Mr. President, is this: if what we're trying to do is put in place an equivalent foundation of legislation in Wyoming statute that mirrors the federal statute, then there are two possibilities really with that U.S. Supreme Court decision. The first is that it upholds federal statute, which means nothing would change, there are no problems, and it would fall back to exactly the status quo, so there'd be no need for this legislation. The second possible outcome is that the U.S. Supreme Court would hold that some aspect of the federal law is unconstitutional, which would then immediately render some aspect of our state law unconstitutional equivalently, which would then provide no further protection and would lead to an equivalent situation, which would then, Mr. President, require that we come back here and find a way to fix that and remedy it. So after having the opportunity to think this through a little bit, I guess I'm uncertain what we're gaining from passing this legislation at this time while it's in federal court, until we understand what the federal decision is, and then potentially would come back and provide a remedy if there are concerns that are unaddressed. So I'd like to learn more about it, and I regret the fact that we're on third reading before I'd like to learn more about it, and I apologize to the body for that, but it does come down to what the good senator raised a moment ago, which is that only recently have any concerns been raised. I thought everything was sorted, as I think the rest of the body did. So if there are proponents beyond the good legislator or the good senator from here in Laramie County that could provide some background prior to her standing up for her second time, I think it would be useful to discuss this further, Mr. President. Thank you.
Further questions? Senator Case.
Mr. President, I think there's kind of a fallacy in this line of thinking. We actually don't know what the federal court's going to rule. I think we suspect that some parts of the Indian Child Welfare Act will be overturned. We don't really know what the basis will be. We don't know if there will be cultural exceptions. There's just a lot of things we don't know. So this bill is sort of a support mechanism for our state policies until we do know. And so we most explicitly don't know that something overthrown in the federal law would overthrow our state law. We just don't know that. And I think it's a reach to be able to say that. Our state law may provide a stopgap to continue what we've been doing now until we really get this whole thing sorted out with Supreme Court direction. We participate very closely with tribal governments to provide Department of Family Services on the reservation. They have their own programs, which we fund and support. We do this by contract. We agree to all things within the contracts. I won't tell you it's always been smooth, but it's been a good relationship, and it's been a better relationship for Native American children. The worst time was when we first started, when the Department of Family Services off the reservation was trying to provide services on the reservation, and that didn't work out very well. You know, the reservation is a really tough place, can be. People are trying very hard. I am not 100% convinced about this bill, I will tell you that. But I think it's important to have this support mechanism in place as we go forward to try to figure out what we should do. And as another part of it, I don't know where it is, but there's actually a task force bill to try to get more people thinking about this, Native and non-Native, to try to find a better way to go forward. In the meantime, this just holds it together so we can keep doing what we're doing now the best we can until we get better solutions. I hope that's helpful, Mr. President. Thank you very much.
Your Salazar.
Mr. President, so I've sat on tribal relations for the last 2 years, and I'm not 100% on this bill either. And my name is on this bill, but I received a number of phone calls this weekend of concern about this bill, and I wish we had more time. I really do. I wish we had more time. This is clearly far more complex than my knowledge spans with regard to this issue. And at some future time, I hope that the legislature will dive into this issue more in-depthly, because we all are concerned, obviously, about children, our children in this state. But I am not at all 100% gung-ho on this bill. So thank you, Mr. President.
Your comments, Senator Nethercott.
Thank you, Mr. President. I do think the good senator from the ivory tower identified the issue squarely before the body for what the Supreme Court will likely do. Of course, anytime the U.S. Supreme Court is interpreting a law that's been on the books for decades, that creates a great deal of anxiety, particularly when it is dealing directly with children and their futures and how they may be taken care of for those most vulnerable. But I do think it's important to recognize the Supreme Court's really limited jurisdiction in interpreting these, which does have to do with constitutionality. So the United States Supreme Court will determine whether or not all or parts of the Indian Child Welfare Act are constitutional. I think it is reasonable to conclude that this body will be back needing to amend this law in light of that decision and as a result of the passage of this bill. That said, that may be a prudent exercise for those in this chamber and for our tribes to really evaluate whether or not this act is working in the way that they'd hoped, or whether or not the passage of this bill is in response out of fear for no other meaningful alternative in place. So I do look forward to future work of this committee in understanding the failures of the act and how it can be resolved in this state recognizing then that future concern over a state law associated with a federal law overlapping concerning the welfare of Indian children.
You're Ellis, second time.
Thank you, Mr. President. Great discussion, and I'm glad we're having it. To address the senator from the Ivory Tower and my colleague from Laramie County, this is a little more complicated. There are two essential arguments that are pending before the Supreme Court. One has to do with the race-based classification. The argument goes, in this country, we are not allowed to pass race-based legislation. But Congress, because it has this unique relationship with Indian tribes, is allowed to legislate based on the political classification of being a member of a Native American tribe, a federally recognized tribe. So that's the first dispute that the Congress is going to look at. Is the Indian Child Welfare Act race-based, and therefore we're doing equal protection, race-based classifications, or is it permitted as a member of a political class? The entire body of federal Indian law is built on this premise that it's a political classification. So when I look at the case, if Congress decide, or the US Supreme Courts decide to say this is race-based, we have big issues we need to talk about as a country and in this particular area of the law. So I actually don't think the court's going to go down that path. So the second argument, if they uphold the fact that Congress can regulate Indian relations through acts like this, then the next question that the court will look at is, did Congress overstep? Many of you are familiar with this, our 10th Amendment protects states' rights, and there are certain activities that states engage in that are generally reserved to states where the federal government has limited jurisdiction. Police power, education, family law. So if the court were to say, yes, you can have Indian Child Welfare Act, but it just can't be done by the federal government, but states can do it, that's what this is seeking to address. And so if the court comes out in that regard, come this spring, we want to make sure that we have a full understanding and cooperation with our tribes that nothing's going to change. Right now, the obligations are for us to provide notice requirements, and if requests are made and the tribal court has authority, we can have those cases transferred to tribal court. This simply maintains that status quo until we can look at the issue closer and decide if we want to make adjustments or not to this act. My fear, if we don't have this bill, is say the courts say you can still have a race, that this isn't a race-based classification, it's one of political status, but we don't have this on the books. There will be confusion, I think, among our state agencies about whether or not they should still provide notice to the tribe. All the protections they provide to Indian parents, should they still do that? Or are we not doing that? They'll be asking the governor's office. Maybe you'll have someone in Fremont County making those decisions, or somewhere else in Wyoming making those decisions. So this prevents that confusion from being there by saying, nope, we're going to continue to do what we've done. And then down the hall, there is a bill that would have a task force that could see if we could do it better. And other states have had task forces. They've had those conversations to see if there's a way that both of our sovereigns or all of our sovereigns can work together to sort out those really difficult issues. So that's the importance of this, Mr. Chairman. It's way more complicated than, well, if the court invalidates it, it goes away and it's meaningless, or if we have it, then we're just having another layer on there. This really is an important stopgap to make sure that those kids don't fall through the cracks through confusion, which is out there, which happens when the Supreme Court makes big decisions that are huge departures from their prior precedent. So with that, I would urge your aye vote on this bill.
Question being called. Having been read 3 separate times, the question is, shall this bill pass the Senate? Senate File 94, Federal Indian Child Welfare Act Codification, pass the Senate. Chief Clerk will call the roll.
Senate File 94, roll call. Anderson? Aye. Baldwin? Aye. Barlow? Aye. Beitman? No. Boner? Aye. Bouchard? No. Brennan? Aye. Case? Aye. Cooper? Aye. Dockstetter? Aye. Ellis? Aye. French? No. Furphy? Aye. Garou? Aye. Hicks? No. Hutchings? No. Ide? No. Jones? Aye. Kinski? Aye. Kolb? No. Landon? Aye. Larson? No. McEwen? No. Nethercott? Aye. Pappas? Aye. Rothfuss? Aye. Salazar? No. Schuler? Aye. Scott? Aye. Steinmetz? No. President Driscoll?
Aye.
Aye. Closing vote. Closing. Vote closed. Senate File 94, 20 aye, 11 no.
Having received the affirmative vote of majority of the members elected to the Senate, Senate File 94, Federal Indian Child Welfare Act codification has passed the Senate. Mr. Majority Floor Leader.
President, I move we stand in recess until, pay attention here, 2:30. We're going to allow these committees that meet at noon to get some bills cranked out. So we will stand at recess until 2:30.
Are there any announcements? 2:30. Senator Biden.
That's when you go to Dennis.
Thank you, Mr. President. Your committee number 3 revenue will meet in 30 minutes upon that gavel of yours hitting the desk in committee room W6 to take up the following 4 bills. Senate File 136, Property Tax Relief Assessment Rate Reduction. Senate Joint Resolution 12, Constitutional Amendment, Property Tax Valuation. Senate File 110, Personal Property Tax Exemption. And Senate File 101, Wyoming Legal Tender Act Amendments as time permits. Thank you, sir.
Mayor Baldwin.
Thank you, Mr. President. Your committee number 10 will meet at 8 a.m. tomorrow morning, extension room 6 and online to hear 2 bills, Senate File 109, prohibiting chemical abortions, Senate File 80, visitation rights.
Senator Kinski.
Committee number two appropriations will meet today after at 1:15 to consider the following. Senate File 62, Legislator Healthcare 2. Senate Joint Resolution 8, Legislative Stabilization Reserve Account Spending Limits. And Senate File 158, Public Employee Retirement Plan Contributions.
Thank you. Senator Steinmetz.
Thank you, Mr. Chairman. Your committee number 5, Agriculture, State and Public Lands and Water Resources, will meet tonight upon adjournment. And we will meet in room W2 to consider the following bills. Senate File 124, Foreign Ownership of Agricultural Land. Senate File 137, Subdivisions, Fencing Requirements. And Senate File 134, Right to Farm, Real Estate Disclosures.
Thank you. Senator Landon.
Thank you, Mr. President. Your Committee 1 Judiciary will meet tomorrow morning at 7:30 in W4 downstairs to take up the following bills. Senate File 89, Insurance Coverage for Hearing Aids. Senate File 120, Restoration of Civil Rights. Senate File 129, Background Checks, Governor's Office, as time permits. That's tomorrow morning, 7:30. Thank you, Mr. President.
Senator Jones.
Mr. President, privilege of the floor.
Granted.
Can we welcome a few members of Wyoming Realtors Association Board of Directors?
We can.
Thank you.
Thank you. For those that missed out, they put on a great party last night. So you've heard the motion. All in favor, say aye. Aye. Those opposed, no.